Hello and welcome to the channel. The Supreme Court has fixed March 3rd as the day for verdict in the ongoing case brought to it by the state government against the federal government as regard the Naira swap deadline and the subsequent non-legal tender status of the old notes of 200 Naira, 500 Naira and 1000 Naira. Although, despite the court ruling against the federal government enforcing said deadline until after the hearing of the case, the president last week declared that while the old 200 Naira notes will be allowed back into circulation until April 10, 500 Naira and 1K notes don't cost, as in, no be money again. The issue don't continue to bring pain and hardship on Nigerians who not even fit get access to the new notes when they make because e not dey available. The Supreme Court, meanwhile, while declaring judgment will be passed on the suits next month, said the federal government and the states won't use them the apex body as scapegoat in the ongoing case, but e no go work. Let's get to the news proper. Subscribe, like, share, and comment. Thank you. Naira crisis. Supreme Court fixes March 3rd for judgment. The Supreme Court yesterday slated March 3rd to deliver judgment on a consolidated suit 16 states filed to nullify the decision of the federal government to ban the use of whole 200 Naira, 500 Naira and 1000 Naira banknotes as valid legal tenders. A 7-man panel of the Apex Court okayed the matter for judgment after all the parties adopted their briefs of arguments. The development came on a day the court warned that it will not allow either the federal government or the aggrieved states to turn the judiciary to a scapegoat in the legal dispute, trailing the new monetary policy that was introduced by the Central Bank of Nigeria (CBN). Head of the panel, Justice Inyang Okoro, bemoaned the fact that the dispute had placed the judiciary in the eye of the storm. With the way this matter is going, they want to make the judiciary a scapegoat, but we can't allow that. We are going to hear everything and take our decision, Justice Okoro added. Though only 3 northern states, Kaduna, Kogi and Zamfara, initially approached the court to challenge the planned full implementation of the Naira swap policy by the CBN. However, at the end of the proceedings on Wednesday, the number of states that declared their interest in the matter increased to 15. The states that persuaded the Apex Court to join them as interested parties in the suit were Lagos, Cross River, Ogun, Ekiti, Ondo, Sokoto, Jigawa, Kano, Rivers, Nasarawa, Niger, Abia, and President Muhammadu Buhari's home state, Katsina. Plea by Plateau State to be joined on Wednesday was rejected by the court, which asked all other states to await its decision on the matter. Even though only the Attorney General of the Federation and Minister of Justice, Mr. Abubakar Malami's son, was initially cited as the sole defendant in the matter, however, both Edo and Bayelsa states filed applications to be joined as co-defendants in the case. The 2 states, through their respective attorneys general, said they were fully in support of both the federal government and the CBN. Meanwhile, Zamfara State, through its lawyer, Mr. Abiodun Owonikoko, son, urged the Apex Court to set aside the broadcast that President Muhammadu Buhari made on February 16, wherein he okayed only the whole 200 Naira banknotes to remain a legal tender till April 10. Owonikoko San argued that the president's directive was a direct affront on the interim order of the Apex Court that restrained the federal government from proceeding with the full implementation of the disputed monetary policy. He prayed the court not to exercise any discretion in favor of the federal government since it refused to comply with its interim order. Subscribe, like, share, comment, and please turn the notification bell on. Thank you. Likewise, Lagos State, through its AG, Mr. Moyosore Onigbanjo's son, told the court that its case was different, lamenting that the new monetary policy by the CBN constrained it from carrying out its statutory functions as a state. Lagos maintained that it did not institute its action on behalf of its residents, but for itself as a state of the Federation. Kano State, while adopting its processes, told the Supreme Court that it was in possession of a security report that warned that it could face a breakdown of law and order due to hardship its residents are facing owing to the ban on the use of the old 200 naira, 500 naira and 1000 naira banknotes as valid legal tenders. The state, through its team of lawyers led by Mr. Sanusi Musa, told the Apex Court that contrary to provisions of the 1999 Constitution as amended, President Buhari failed to consult the Federal Executive Council (FEC) before he gave the CBN the nod to invalidate the old naira notes. My lord, no meeting was held with members of the FEC to take any decision on the CBN's demonetization policy. Here, we have a situation where the president only took advice from the CBN governor, who is not a member of the FEC. He sidelined members of the FEC and proceeded with the policy. The issue was never discussed at the FEC meeting. In fact, even the Minister of Finance had, after the policy was announced, publicly stated that she was not aware of it. The president unilaterally exercised executive power in cahoots with the CBN without recourse to states that are members of the FEC. As it stands, my lords, we have a security report from Kano State that there may likely be a breach of law and order, Musa San added. He therefore prayed the Apex Court to void the Naira swap policy and okay the whole banknotes to remain valid legal tenders. All the plaintiffs urged the court to grant all the reliefs they are seeking against the federal government. However, federal government team of lawyers led by a former AGF, Mr. Kanu Agabi San and Tijani Ghazali San, prayed the court to dismiss all the issues that were raised by all the states that are opposed to the Naira redesign policy. Agabi San equally prayed the court to dismiss the motion the states filed to void President Buhari's directive on the whole Naira notes. While insisting that the Federal High Court was the appropriate place for the states to ventilate their grievance, Agabi San noted that though the plaintiffs sought to commit the CBN governor, Mr. Godwin Emefiele, to prison for allegedly flouting the interim order, they however failed to join him or the Apex Bank as parties to the suit. My lords, this suit cannot be commenced here at the Supreme Court. They are crying in the wrong place. The Supreme Court has no original jurisdiction to entertain this matter. Moreover, reference was made to the CBN 32 times in the originating summons in which they did not join the CBN as a party, Agabi San added. Besides, he told the court that President Buhari's decision to withdraw the whole banknotes was to avert a calamity he said would have befallen the nation. Long before the court made the interim order the plaintiffs are relying on, Nigerians were already rejecting the whole notes. Even in the Supreme Court, they were not accepting it. After they had listened to all the parties, the Apex Court adjourned the matter for judgment. That's the news, guys. Thanks for listening. Until next time, bye.